We start with a Fox News alert. Huge breaking news. The United States Supreme Court just ordered a response to the legal challenge that was filed by the state of Texas, where officials there are now contesting the election results in Georgia, Wisconsin, Michigan, and Pennsylvania. This is the blockbuster suit we told you was likely coming, and we began to discuss. The deadline for the response is Thursday by 3 p.m. This challenge has now officially survived outright dismissal, contrary to what many experts were predicting today. Could be a game changer. We will lay out all the case, and we'll have exclusive reaction from the person that brought that suit, the Texas Attorney General, Ken Paxton, also Kayleigh McEnany. We begin with first tonight, though, you need to know about this critical new challenge. All you need to know, mob, the media, they will all dismiss it. This is a well-written case. It was well thought out, and it was well delivered, and apparently received well enough that they want to hear arguments. And first and foremost, Article 3 of our U.S. Constitution. This is really not complicated. Stay with us. Requires the case be filed directly at the U.S. Supreme Court, which has what's called original jurisdiction in disputes between multiple states. If the Supreme Court decides to take up the case, the justices will be tasked with deciding whether or not these states, Georgia, Wisconsin, Michigan, Pennsylvania, whether in fact they violated the U.S. Constitution in a variety of ways. That is all laid out right here in this suit brought by Texas. It includes Article 2 of our Constitution, which clearly articulates the following. Each state shall appoint in such manner as the legislature thereof may direct a number of electors. In other words, it is constitutionally up to state legislatures to decide election policy. For example, in Pennsylvania, we already all know this was clearly violated when the mail-in ballot deadline was pushed back without lawmaker approval. Article 2 was also likely violated, as we've been telling you, in the state of Georgia, with that idiotic consent decree, which relaxed the signature verification requirements in mail-in ballots, creating what was an unequal system. This policy was once again done without lawmaker approval. It was a consent agreement but with the Secretary of State of Georgia, and constitutionally, as we pointed out, it is the legislature of Georgia that should have decided any such thing. Well, remember, that lawsuit was brought by the Georgia Democratic Party, the Democratic Senatorial Campaign Committee, and the Democratic Congressional Campaign Committees. This was a consent agreement just with the Secretary of State, not with the state legislature. And that's not all. This new Texas suit also alleges multiple violations of what is known as the Equal Protection Clause and relies on very compelling court precedent. Chris Kobach had a great interview with me on radio today, pointed out in a terrific op-ed. In the landmark case, you've heard of it, Bush v. Gore. The U.S. Supreme Court held that it violated the Equal Protection Clause of the 14th Amendment when one Florida county treated ballots one way and another Florida county, they treated ballots a whole different way. We saw clear examples of all of this unequal treatment among counties in state after state. Now, that includes vastly different policies for election observers, poll workers, and vote counting procedures. In Michigan, for example, we know some of the counties denied access to any partisan observers, which the statutory language calls for, and other counties forced observers back at a distance of 6 feet, others 20 feet away from the vote counting process, which prevented them from doing what they were legally allowed to do and, frankly, was written into the law. Other counties decided to allow full access to partisan observers. Ask yourself, how is that unequal application of the law? Make no mistake, this case deserves to be heard. It has merit, it has precedent, and the American people deserve their day in court. Now, keep in mind, during a presidential election, if laws are violated in one state, voters in every other state feel the consequences. That would be, let's say, disenfranchising their honest and legal votes. That's why, according to the suit, quote, a dark cloud hangs over the 2020 presidential election. Look at this new Gallup poll. 89% of Americans have serious doubts about this election process. Rasmussen, 57% of Republicans, they don't want the president to concede. And today, the president called on lawmakers, the Supreme Court, to do what is right. Take a look.
Hopefully the next administration will be the Trump administration, because you can't steal hundreds of thousands of votes. You can't have fraud and deception and all of the things that they did and then slightly win a swing state. And you just have to look at the numbers, look at what's been on tape, look at all the corruption, and we'll see. You can't win an election like that. Now let's see whether or not somebody has the courage, whether it's a legislator or legislatures, or whether it's a justice of the Supreme Court or a number of justices of the Supreme Court. Let's see if they have the courage to do what everybody in this country knows is right.
And tonight, like always, we will continue our own independent path. We don't follow the mob, the media, any other show. We do our own thing here. The lawsuit from Texas is a very serious legal challenge at the very least. It has a right to be heard. The country deserves it. You deserve it. We, the people, deserve it. And I don't know what the justices are going to do, but the American people deserve answers. And we need to have confidence in both the integrity and the results of every state's election and the process, because we have millions of innocent Americans in states where the law, the Constitution, were followed. They are then disenfranchised in a corrupt process. It's not okay that partisan observers are blocked from performing what they are legally allowed and the law calls for them to do, their critical duties. It's not okay that the chain of custody gets lost. It's not okay that election laws are changed by, politicians at a whim in the middle or after the game's been played without any legislative approval. It's not okay that mail-in ballots have different signature verification requirements than in-person ballots. As the Texas suit perfectly describes, quote, our country stands at an important crossroads. Either the Constitution matters and must be followed, even when some officials consider it inconvenient or out of date, or it is simply a piece of parchment on display at the National Archives. We ask the court to choose the former. In the coming days, the U.S. Supreme Court now will send an important message. Make no mistake, whatever happens, this will have serious, long-lasting implications, ramifications for every single election to come. And that's why tonight, every decent Republican attorney general with a brain needs to get busy working on their amicus briefs to support this Texas suit.